Good afternoon, everyone, and welcome. My name is Gila Franklin Siegel, and I am the Associate Director at the Jewish Community Relations Council of Greater Washington, which serves as the public affairs and community relations arm of the organized Jewish community in our region, representing more than 100 organizations and synagogues throughout the DMV. Our agenda encompasses legislative advocacy at the state and local levels, interfaith and intergroup relations, Holocaust education and awareness, and K through 12 education, outreach, and services. One of the cornerstones of the JCRC's mission is Israel education and advocacy. We sponsor numerous programs throughout the year that deepen understanding of Israel's government, geopolitical challenges and opportunities, and societal growth to increase knowledge about Israel in all its wonders and complexities in our region. Today's discussion is part of our long-running Brown Bag Lunch series for lawyers. In pre-COVID days, these programs were held at the law offices of JCRC past President Harvey Reiter. These days, we take our Brown Bag Lunches in front of our computer screens, grateful for the technology that has allowed us to continue to learn and dialogue together. We are thrilled to have such a large number of people joining us today. Due to the size of the crowd, we are utilizing Zoom's webinar capability rather than the meeting function, but you will still be able to ask questions using the Q&A icon at the bottom of your screen. I would like to thank our steadfast Brown Bag Lunch partners, the American Jewish Committee, the American Association of Jewish Lawyers and Jurists, the Jewish Federation of Greater Washington, and Tzedek DC. I would also like to take this opportunity to give a special thank you to Allison McWilliams, the Executive Director of the Naomi and Nehemiah Cohen Foundation, not only for her assistance in today's program, but for her continued partnership, leadership, and friendship over the years. And a final thank you to the outstanding director of the Lessons Israel Action Center of the JCRC, Adam Odesser, who worked tirelessly to put this program together. And now to our discussion. As you may know, Israel's judicial system differs dramatically from our American constitutional system. Israel lacks a constitution and relies instead on a foundation of basic laws. It is considered a mixed legal system that includes elements of English common law and Ottoman legal codes and is influenced by Jewish, Christian, and Muslim religious laws. As in any democracy, Israel's judiciary is at the fulcrum of the nation's most pressing societal challenges and tensions surrounding civil rights, equity, government integrity, and balancing individual rights with the state's authority. To discuss these topics and more, I am truly honored to introduce our speaker and our moderator for today's program, Professor Mohammed Wattad and Richard Foltin. Professor Wattad is the Dean of Law at Tzfat Academic College. He is also a senior researcher at the Institute for National Security Studies at Tel Aviv University and a research fellow at the Minerva Center for the Rule of Law under Extreme Conditions at Haifa University. He's the first Muslim law school dean in Israel and is the youngest person to become a dean. Professor Wattad specializes in many fields, including international and comparative criminal law, the laws of war and torture, laws on terrorism, and the interaction between law and political science. He is a Haifa University School of Law graduate and has studied and taught law in several countries, including Germany, Italy, Canada, and the United States. He is the recipient of many honors, including the Zeltner Young Scholar Award, the Mayoff Prize, and the Best Legal Oralist Award of the International Institute of Higher Studies in Criminal Sciences. Professor Wattad, we are honored and grateful to have you joining us here today. I'm also delighted to welcome my longtime colleague, Richard Foltin, who is a fellow for religious freedom at the Freedom Forum. Richard served for many years as the American Jewish Committee's National and Legislative Affairs Director in Washington, D.C., where he was responsible for AJC's policy and advocacy initiatives on a broad range of domestic and legislative issues, including religious liberty, civil rights, immigration, energy security, and combating domestic anti-Semitism and anti-Israel boycotts. During his long tenure at the AJC, Richard was widely recognized, and still is, as one of the community's thought and advocacy leaders on all of these critical issues. He has a BA in political science from New York University, and his law degree is from Harvard Law School. Richard and Professor Wattad will begin with a conversation, and at about 30 minutes in, Richard will begin taking questions from the audience. If you have a question at any point, please use the Q&A feature found at the bottom of your screen. And now I would like to turn our discussion over to Richard. Richard, the screen is yours.
Thank you. Professor Wattad, and we've agreed to be on a first name basis here. So Mohammed, it's really an honor for me to have the opportunity to engage in this conversation with you about, I think, some very challenging issues, but also as an educational mechanism for people to learn about the Israeli legal system and how it operates. As a political science major myself, and then as an American trained lawyer, I was inculcated with the primacy of the Constitution as a sine qua non to adequately protect civil rights and civil liberties. Not only do we have a federal constitution, but also each of the states has its own constitution. But as we are all too keenly aware, many countries have constitutions that ostensibly afford broad protections, but for whom those protections, in the absence of an independent judiciary or the habits of heart, to use a phrase from a Jewish scholar, in which respect for difference is norm, makes those protections a dead letter. On the other hand, neither the United Kingdom nor the State of Israel have written constitutions, and yet they have systems with all the failings of any system constructed by human beings that aspire to safeguard the civil norms that the U.S. Constitution, at its best, also protects. So, Mohammed, I'd appreciate if maybe we could start with a primer of sorts on the Israeli legal system, with particular attention as to why Israel has no written constitution and what plays the role of a constitution in that system. So the floor is yours.
Well, thank you very much, Richard. I'm glad to be with you here, and I'm grateful for this kind of invitation. Many thanks should also be due to the participants. I'm happy to see that more than 90 people have decided to leave all the important things that they have to do in life, and they join us here. I see some of the names of which I'm familiar. Michael Treason is here. So I can't see you all, but I see the names, so I'm happy to be here. Well, here's the thing. Israel is a unique country in many aspects, even in constitutional law. For many years, we were told that the reason that Israel does not have a constitution is the fact that Israel has been involved in many wars since its inception, and therefore there has been no time to write a constitution, which is ultimately a true fact, by the way. But there are many other reasons why Israel does not have a constitution. One important reason, or another important reason, is the fact that upon the establishment of Israel, there were the local Jews, but at the same time, there were Jews who came from different countries in the world. Most of them came from different, completely different judicial systems, say for America, for instance, from America or from Eastern Europe or from Western Europe. And therefore, there was no consensus over the common ground for establishing a constitution. There are others who came from Arab countries at the same time. And there was the big elephant in the room. What is the relationship between Israel as a national home for the Jewish people and Israel as a Jewish, in the religious aspect, state? So what is the relationship between the Constitution and the Bible? And these issues are very sensitive. But there is another reason, and I might say quite definitely that it's the prominent reason. Ben-Gurion didn't want a constitution. Ben-Gurion was a very sophisticated person. Professor Kedar wrote a book about that. He well understood that a constitution means definitely limiting the governmental power. As a politician, he wanted to remain in power, to the extent that upon the establishment of Israel all the way up to the 80s, the way judges were appointed was a pure political process. The government, and if to be more particular, the prime minister decided who are going to be the judges. However, this is not the way the judges perceive themselves. while Ben-Gurion perceived judges, the judicial branch, the whole judicial branch, as the long arm of the government, the judiciary in Israel perceived itself as an independent branch. They didn't see themselves as working for the government. And later on, when we discuss certain cases, I will show you how, since the very inception of the Supreme Court justices clashed with the government, way more than the clash that we witness nowadays in Israel between the political branches and the Supreme Court of Israel. So to put all together, these are the reasons why we don't have a constitution. But at the same time, we have decided we are a high-tech country, so we invent things. We invented a very unique methodology of establishing a constitution. If we cannot establish a consensus over the main pillars of a constitution, then we decided to make it step by step. So the parliament in Israel, which has two hats as a constituent assembly and as the legislature, decided that we will establish a constitution chapter by chapter. Every chapter upon which we agree, we will conclude it as a constitutional statute, and then later on in the future, we will assemble all these basic laws together and we call it a constitution. But we did not decide how many basic laws we need. We did not make any decision about which basic laws we need. We did not decide on the question, what will be the legal status of these statutes, basic laws upon their establishment, about their legislation. So we started with basic law, the parliament, obviously. So we have a parliament. We continued with basic law, the government, so we have a government. And then we continued with other institutional basic laws, but we did not two things. We did not establish basic law, the judiciary, all the way up to the 80s. And we did not establish any basic law concerning human rights. Only in the 80s, we remember that we need a basic law called the judiciary. So the judiciary in Israel is incorporated in a basic law, which means that it has constitutional status, granting it for the first time a clause that says that the judiciary is not bound, but only by the rule of law, etc., etc., etc. And it happened only in the 90s that the Knesset remembered to legislate two basic laws. One deals with the freedom of occupation, working, employment, etc., etc., and the other one, basic law, human dignity and liberty, which supposedly, supposedly because it's not comprehensive, it grants constitutional protection to certain constitutional rights, but not very comprehensive as in many European countries or even as in the American constitutional system. So that's the background for the constitutional law status in Israel. But at the same time, you can understand, given the fact that judges were appointed in Israel from the very beginning, coming from different countries in the world, we had the influence of different legal systems. So we have Chief Justice Agronat, who used to be Chief Justice of the Supreme Court. He's an American Jew, and we will see the American constitutional values, First Amendment, for instance, coming all the way into the Israeli legal system. But we had other judges coming from Europe, from Germany, for instance, and we'll see particularly in civil law, the influence of the civil code of the European countries and legal systems. But at the same time, we have also religious jurists who try to influence the legal system with some halakha, with some religious precedents from the Hebrew heritage. Step by step, we start becoming a leading nation among other nations in the world in so-called comparative law, which I understand that in America it's a sensitive issue because American Supreme Court does not like the idea of referring to comparative law. But in Israel, we refer to comparative law. Sometimes we do that with methodology. We refer to countries which resemble us in terms of our constitutional systems. But in many other instances, we basically refer to every possible comparative legal system of which we are aware, and then we see if there is any solution that might suit our legal apparatus.
So let me ask then, first of all, in terms of this methodology of looking to the courts looking to other countries, do they then establish perhaps it's not a basic law, but are there what amount to constitutional protections that the courts have in fact provided? Freedom of speech, freedom of religion, equal protection under the law. To what extent are the courts bringing those concepts over and applying them in Israeli cases, even though there's no formal constitution? And the related question is, even if it's not a basic law, are there statutes, either by Knesset or at the municipal level, that provides for some kinds of protections as well, absent basic law?
Well, thank you for this interesting question. We have to, when we look at the Israeli constitutional system, we basically distinguish between two periods of time. One is before 1992 and the other one after 1992. And that's because in 1992, the Knesset legislated basic law, human dignity and liberty. And there are many important aspects about this basic law, apart from the fact that it guarantees constitutional protection for basic human rights. I would say the most important thing in this basic law, and this is actually what the court said later on in 1995 to be called the Constitutional Revolution in Israel, a supremacy clause, saying that all the governmental branches, the parliament, the government, and the court itself, are bound by the rule of law and they're bound by basic law, human dignity, and liberty. Meaning that basic law, human dignity, and liberty is above all governmental branches. The Supreme Court of Israel, led by Chief Justice Meir Shamgar and Professor Aharon Barak, at the same time he was about to retire, Shamgar and Barak was about to be appointed as Chief Justice, led a precedent to be compared by Merber versus Medicine in America, saying for the first time that it is for the court to decide on the interpretation, the proper interpretation of the law, including basic laws, namely the Constitution, that these basic laws are part of Israel's future constitution, and therefore they already establish a partial constitution, and the court may decide that if a law is in contradiction with any basic law, then the court may declare that law as invalid. Now, this is a huge issue. But before that, it was not the case that the court did not do anything in order to protect human rights. When I teach constitutional law, I always tell my students something which I guess most of the people did not witness, at least, looking back to the 50s. In 1950, there was a case before the Supreme Court of Israel dealing with the interpretation of a mandatory legislation of a legal term, that ultimately allowed the Minister of Interior Affairs to strike down a newspaper. And Chief Justice Agronat, who's an American Jew, says the following: in order to interpret that term, I need to understand in which country do I live? Which kind of system? Is it a democracy or a dictatorship regime? Now, the only law that we had at that time, quote to quote, was the Declaration of Independence, which is not a binding law. It's kind of, the credo of the legal system, of the state, etc., etc. And he says, when I read the Declaration of Independence, which does not include the word democracy at all, I understand that Israel is a democracy because it provides some kind of guarantee of equality, freedom of religion, and other human rights. And therefore, I understand that Israel is a democracy. And he says the following, and I'm quite quoting him now. 1950, in our constitutional system, the constitutional right to freedom of expression is a prerequisite for democracy. And then he cites famous American cases on the First Amendment. This is amazing. This is fantastic.
Yeah.
Now, afterwards, after 1992, the case was quite easy, especially that the court was led by Professor Aharon Barak. He's a well-known scholar, and he's well equipped with comparative studies. And he has a methodology who have to do that. So we were aware of things, of legal developments in the world, and therefore it was easy for us to look out and check which kind of solutions does comparative law provide us. But that doesn't mean necessarily that every solution that works in America or in England would work in Israel. We would need to check if it's applicable in the first place to the Israeli apparatus, the legal apparatus. So that's the first part of your question. The second part of your question deals with the fact that basically the only basic law that guarantees human rights in Israel is basic law, human dignity and liberty. But the fact is that this basic law does not guarantee the constitutional protection to many important fundamental human rights, such as equality, the 14th Amendment in America. Now, the reason that we omitted including equality in that basic law was because of the dispute between the ultra-Orthodox Jews and the secular members in the Knesset. The ultra-Orthodox Jews say that we will veto against this basic law if you include equality, because that would allow the Supreme Court of Israel to intervene in the rabbinic courts. And in the rabbinic courts, only the Bible should apply. The rules of halakha and equality goes against, according to their views, goes against equality between men and women. So the Supreme Court of Israel took a leading role in interpreting the basic law in a very creative way in order to, for instance, incorporate equality inside dignity. We have the right to dignity. In America, you had the kind of vice versa process with Brown versus Board of Education, when the Supreme Court basically said separate but equal is not equal. When you read Brown versus Board of Education, the Supreme Court speaks of dignity, of humiliation, in order to give substantive meaning to the right to equality. And this is how the Supreme Court took the rule to interpret creatively the basic law as it exists in order to establish the protection, a wider protection for other human rights. However, other courts in Israel, lower courts than the Supreme Court, they did not take a particular role in establishing human rights, not because they didn't want, but because they are not authorized in the first place. I mean, in principle, they are authorized according to the Supreme Court. However, the Supreme Court has said that more than once, that leave it for the Supreme Court of Israel. In any case, we are troubled by the fact that we kind of hyperactive Supreme Court. We don't want to have criticism from the politicians by the fact that lower courts decide which law is constitutional, which law is unconstitutional.
Well, that has been an issue in Israel, hasn't it? I mean, there are people that are critical of the High Court for being too forward-leaning, anti-democratic. How has that played out? I mean, has the court paid any attention to that criticism, or just continues to do what it thinks is the right thing to do?
This is a very interesting point in Israel, because all the way up until 1992, the Supreme Court of Israel has been very active. I just gave you one example, but the Supreme Court decided in the 60s that there is a constitutional right to freedom of occupation. In the 70s and in the 80s, they decided that there is a constitutional right for equality, dignity, privacy, even without having a basic law that speaks of human rights. The thing is that all the way up to 1992, the Supreme Court basically struck down governmental policies, but they never struck down any legislation of the Knesset. Once the court directed legislation of the Knesset, the issue became hot, because the argument was we were elected by the people. We are supposed to be the supreme player in the field. You, the judges, were appointed by a special committee. You were not elected by the people. You don't have the legitimacy to do what you're doing. For many years, the debate has been very elegant, but in the recent, I would say, 10 years, there has been a counter response from politicians who decided that enough is enough, and therefore they came up with different proposals, for instance, to influence the way judges are appointed, to establish a not with understanding clause, such as in Canada, whereby the legislature may legislate something which the court has decided that it's unconstitutional and it should be remain valid as constitutional despite the court's decision. Now, ultimately, I would say quite confidently that this whole debate has been more of a debate, rather we see something on the ground. The problem is that some of the audience might be aware of the recent incident where one of the leading members of the opposition in Israel from the Likud party has argued that Chief Justice of the Supreme Court of Israel, Esther Chayut, dismissed his petitions because he's a Mizrahi, came to Israel from an Arab country, and he's not Ashkenazi, arguing that she is racist. And then she responded to him in a very presidential step, unfamiliar step, in a personal public letter, telling him of her history as, as being raised up in the Ma'abarot with the Mizrahi and Ashkenazi together, being brothers and sisters, and that she has nothing against that she doesn't speak the same language as he speaks, and there's been big fuss in Israel. So yes, I would dare even to say that there are those who, encompass this debate against or this position against the court in order to become famous in the news. Once you attack the court, then somebody speaks about you in the media. That's unfortunate ultimately, and I have to say that with lots of appreciation to the Supreme Court of Israel. As a legal scholar, I may not agree with every case or every decision of the Supreme Court. I might definitely criticize these particular decisions, argue against them, but to target the self-legitimacy of the Supreme Court of Israel, the institute for which we are so proud when we go abroad. I mean, even the Ministry of Foreign Affairs for many years, when they do their Haspara, they cite cases of the Supreme Court and say, look at us, we guarantee human rights, even to the Palestinians, to women, to the Arabs, to the ultra-Orthodox Jews, to the LGTB and other weakened groups in the society. And so, and therefore it's very important to protect the Supreme Court of Israel. Basic law, some of our basic laws, in America, in order to amend the Constitution, you have to go through a very complicated process. It's not easy to amend the Constitution. The entire majority of the basic laws in Israel are not even entrenched. You can change them by any majority in the parliament. Some of them are entrenched by a majority of 61 members of the parliament, out of 120 members. But basic law, the judiciary, is not protected in any way. In principle, 2 members of the parliament may completely invalidate the Supreme Court of Israel. Now, the fact that this has not happened means a lot, that there's a big gap between rhetoric and what happens on the ground. But I would say that it is time first to entrench this important basic pillar, which is called the Supreme Court of Israel, that represents the rule of law in its very substantive meaning, not only in the formal meaning of the rule of law. And it's time to do that.
So let me just ask then: the basic laws are passed by a simple majority. You don't need a super majority of some kind to pass a basic law?
Well, unfortunately not. That's one of the problems, that the Knesset holds 2 hats at the same time, but there's no distinction in the process. So the way you legislate any regular statute is the same way the way you legislate a basic law. Now, nowadays we are more familiar, we are more aware of the special legal status of basic laws, and therefore there is this long political debate in the parliament, in the special committees, professional committees in the parliament. You would ask the Attorney General of the State of Israel and the Attorney General of the parliament to give his opinion or her opinion on the constitutional questions regarding these basic laws, etc., etc. But the process is the same, and you don't need any special majority in order to legislate in the first place any basic law. All the more so when you want to invalid a basic law. Most of them are not even protected. I mean, basic law, human dignity and liberty, which is our constitutional revolution, you can invalidate it by a simple majority of 2 members of the parliament against 1, and that's it. It's gone. that's a problem. So Justice Dalia Dorner of the Supreme Court of Israel has suggested for many years that see, we don't really know when we will have a constitution in Israel. I even dare to say that it's not in my generation, even in my daughter's generation. But to be realistic, let's first and foremost protect the existing basic laws. Make sure that they cannot be amended by any majority, simple majority in the Knesset, so that we have kind of stability. Otherwise, we don't have stability. And to be true with ourselves, the recent 2 years have exemplified to us how unstable we are during the COVID-19 crisis. Supreme Court was flooded by many petitions that targeted serious issues concerning basic human rights, which are not even protected by our basic law. And the second issue was the political crisis that we went through. We went to the poll to vote 4 times in 1 year in order to, and then we had the 5th time in order to compose a government in Israel. And these incidents, these 2 crises just showed us how unstable we are. The fact that you can start changing, amending basic law of the government, which is one of the most important institutional basic laws in Israel, in a second, overnight, only for the sake of establishing a coalition to the left or to the right or to the center, it doesn't matter, means a lot. This is bad. This is not good. I mean, I, as a constitutional law scholar, I had to amend my syllabus like hundreds of times in 1 year. This is not how you do constitutional law. I mean, we can look at American constitutional law and learn a lot from them. You know, the way the process goes. Sometimes, I mean, we like things that happen there. Sometimes we dislike, but still, the process. You have a process. You have a book, and that's one of the questions. One of the answers. Why do we need to have a written constitution? You cannot argue over everything. You have to have a document first and say, this is my constitution. Now I know the framework. After that, we can discuss, we can debate the essence of that book.
Okay, let me turn, we've got questions that are accumulating, but before we turn to questions from the audience, and perhaps this will respond to some of those anyway, you know, we've talked about the Constitution in general, but I'd like to focus now. You're a member of a minority in Israel. I think in our previous discussion, you commented in Israel, everybody's a minority of some kind or other. So I'd be interested to hear how you feel professionally, but even personally, about the extent to which minority rights are protected, whether by the non-constitutional constitution or by the operation of law generally. What is the situation of those who are minorities in Israel, whether it be having to do with schooling, housing, enforcement of the law? What's being done right, and what could be done better to protect the interests of minorities in the state of Israel?
Well, I'd like first of all to endorse your statement that everyone in Israel is a minority. We have never spoken about that before, me and you, but I have been saying this again and again, that interestingly in Israel, every person belongs to a certain minority. At the same time, you can also be deemed as a majority if compared to another group. So for instance, as an Arab, I belong to the Arab minority in Israel, which is about 21% of the whole entire population in Israel. But as a Muslim, among the Arabs, I belong to the majority Muslims compared with the Druze or the Christians in Israel. The same goes for instance, for Ashkenazis and Mizrahi, ultra-Orthodox Jews, and secular men and women. You know, women in Israel are, numerically speaking, they're a majority, but substantively speaking, they're a weakened group, and therefore they are deemed as a minority. And it's not easy to be a minority. It's definitely not easy to be a minority, particularly in a state which is defined as a nation-based state, Jewish and democratic state. I'm not a Jew, even if I convert by, my name will become Moshe Cohen instead of Mohammed Wattad. Still, I'm not a Jew, and I doubt if anyone will deem me as a Jew for the sake of national identity. But this is not the point. Israel was established as a Jewish and democratic state, and to my humble opinion, there's nothing wrong about that. I mean, the self-legitimacy of establishing Israel is as a Jewish and democratic state. The question, what does it mean to be a Jewish and democratic state? I read Jabotinsky. I read the partition plan. I read the Declaration of Independence. If the Declaration of Independence has become the constitution of the state of Israel, I think the rights of minorities in Israel, including the Arab minority, would be way better protected in the state of Israel. Now, in the recent years, we have heard many leading political leaders, including prime ministers, the current prime minister and others before him, Benjamin Netanyahu, Ehud Barak, even Ariel Sharon stated that, Rabin said that, Peres said that the Arab minority in Israel has been discriminated against institutionally for many years. In the recent years, there has been a governmental decision that it's time to compensate them for that. Starting with the kind of cost-benefit analysis, if their socioeconomic status is better, it will return with benefits on the state of Israel. Afterwards, as you may know, there's one Arab party has joined the coalition in Israel. So the issue has been a matter of principle, not only a question of cost and benefit analysis. Now, on the ground, speaking on the ground, the Arab minority in Israel are discriminated against in many issues, starting with funding. I'm speaking now official numbers. If a kid in an Arab village receives 1 shekel, then a Jewish kid in a Jewish city next to like Tira and Kfar Saba in the center of Israel would be receiving 25 shekels, that multiple 25. Housing issues, land allocation. Most of the land in Israel belongs to the state. Since the establishment of the state of Israel, there has never been the case of establishing a new village, Arab village. So you have a big issue about housing in Israel. But for that, there are many things to be done. And I dare to say that many things to be done by the two sides. When I say the two sides, I don't say the Jews and the Arabs, because we are all Israelis. What I say by the state and by the Arab minority. Now, the state represents all of us. It doesn't represent only the Jews. And now, why do I say the state? Because the state has the means, it has the power, it has the money, the finance, it has the amazing power to change reality. But at the same time, also the Arab minority in Israel has to decide that they want to dance with the state. And when I say to dance with the state, that they have to comprehend the fact that they are Israelis and that there's nothing wrong with stating that I'm Israeli. You don't become a Zionist if you say I'm Israeli. This is my citizenship identity. I should be proud of my citizenship identity exactly as I'm proud of my national identity, of my religious identity, of my professional identity. So it's a matter of proportionality, of a balance between the multiple identities. Ultimately, in Israel, we all have multiple identities. None of us has only a one identity. So things has to be changed. Now, already at the term of Benjamin Netanyahu, including now, there have been 5 governmental plans, economic plans, in order to put the Arab population in Israel in a better situation. It's not an easy process because, when it comes to implementing the plans, things become very complicated, particularly with bureaucracy in the local municipalities, etc. But the fact that in a historical event, an Arab party has joined the coalition in Israel, I think there is a hope that we start seeing ourselves all as Israelis, and that we need to dance together, and that we need to legislate things in favor of all the citizens alike in order to put the Arab population. Look, we have in Israel certain laws that deal with affirmative action for the Arab minorities. That's quite something. That's important, because without affirmative action, it doesn't matter how fast you run, you never reach the same starting point. So I think things are going in the right direction, but hopefully, we will have a methodology towards the future, and we will not be forced only by political forces in order to love each other, in order to make our situation better.
Well, you know, just in the last day, I think it's been announced that there's going to be among the new Supreme Court justices, the first Muslim justice, and as well as the first Mizrahi woman justice. Do you see that as a hopeful sign? There have been some critics that talk about tokenism, whereas in the United States, when there's a first, we hail that. We say this is wonderful. So I wonder how you see this first Muslim judge on the Supreme Court. So is that a hopeful sign?
Well, look, to start with, I mean, all the 4 judges who were appointed to the Supreme Court, they were appointed because they are good jurists. That's a matter of fact. Particularly the Arab judge, he's like a phenomena in his field, and he's well known as a super judge. He's amazing. However, there's nothing wrong with the fact that he's an Arab and he's Muslim. And as a matter of history, this is for the first time that a Muslim Arab is appointed to the Supreme Court of Israel. This is a historical event. I hope that in the future there will be 2 Arab judges in the Supreme Court. In Israel, we cannot deny identities, and the fact that there are 2 women now that joined the Supreme Court, one of them for the first time is Mizrahi. This is something, I mean, if we argue that Mizrahis were discriminated against for generations, then it's time to mention that explicitly when a Mizrahi woman is appointed to the Supreme Court. So I'm glad for both of them. I'm glad for 4 of them, but particularly for both of them, that they joined the Supreme Court. I hope, I state that again, I hope that in the future there will be 2 Arab judges in the Supreme Court. Ultimately, we have 15 judges in the Supreme Court. The Arab minority is 21%, so I believe that we deserve to have 2 seats. That doesn't mean anything about their legal positions in certain cases, but as a matter of representation of the Arab population in Israel, it's very important to have 2 judges in the Supreme Court.
Great. We've had a number of questions that have to do with Israel's role in the international juridical order. Basically, the questions are, when the ICJ, the International Court of Justice, issued an advisory opinion about the wall, the protection wall, does that have any impact on Israel's judiciary? I'll ask a couple of related questions here. Also, to what extent does Israel see itself as bound to and adhering to international human rights law? And finally, the protection of human rights you've been talking about, how does that play out in terms of the territories? How are those populations distinct from treatment of minorities, of people who are Israeli citizens, and of course in a different legal posture? So that's a lot of stuff bundled into one question, but I'd welcome your thoughts on these issues.
Here's the thing. The relationship between Israel and the international community, to start with, is quite complicated. Many times for good reasons. The international community has not been treating Israel fairly. That's as a matter of fact. And I say that explicitly as a legal scholar of international law. You can't hide that. But at the same time, sometimes you have to be smart, not only right. International law exists. The international community exists. It has its own mechanism. It has its own diplomacy. You cannot just ignore it. You cannot just keep yelling that, they are against us. You have sometimes to address these issues on their merit. Now, for many years, the Supreme Court of Israel, particularly Chief Justice Aaron Barak, were highly criticized by politicians for intervening in the government's actions, particularly at time of war. Those who are aware of the mechanism of the ICC, the International Criminal Court Rome Statute, know that basically the legal intervention of the Supreme Court is the best protection for the soldiers and for the political leaders because of the complementary principle. Particularly if the Supreme Court is so decent as in the state of Israel and decides on issues, regardless the fact that it's our country, etc., when it's time to criticize the government, we do criticize the government. We don't hesitate to do that. This is why we feel so confident sometimes when we are attacked by the international community concerning issues of human rights at time of war. Now, the issue with the Palestinians is quite complicated because, you know, it's a question of occupation, armed conflict, which treaties apply, which treaties don't apply. Ultimately, Israel has adopted two kinds of theories. One is, regardless international law, we apply human rights on the territories, and therefore we don't need international law. But at the same time, they have declared, legally speaking, the situation there as an area of armed conflict, and therefore the rules of armed conflict apply there, including the Geneva Conventions, the Hague Convention, and others, and therefore we apply them. We hold soldiers for trial, for military trial, because they breach certain rules otherwise protected by international law. Now, things are becoming more sophisticated, and we understand that. And ultimately, we have established a particular department at the prosecutor office at the state level, which deals particularly with these issues, which means that we have comprehended the fact that we cannot just, politically responding to these issues, but we need to deal with them legally. And luckily in Israel, we have serious legal scholars in this field. And therefore, I hope that, professionally speaking, their voices will be heard by the right people who make the decisions in crucial issues. Otherwise, we might be embarrassed, the least to be said. So the question is more professional for us, should be, rather than political. But I dare to say that I'm not a politician in the first place. I'm quite sure that the political arena and the diplomatic arena also will active in this matter, and they know what to do.
Thank you. I want to come back to, first of all, an interesting question. You mentioned earlier that there are two members of Knesset could have taken down a basic law. And there was a question, but I must admit I was sort of confused by this as well. Wouldn't you need a majority of the Knesset to take down a basic law? Could you explain a little bit more what you were referring to when you said that?
What I'm saying, no basic law in Israel was taken down. But I'm saying that in theory, if you want to invalidate a basic law, basically is like invalidating any regular law. You don't need any special procedures. You don't need any particular majority. Certain basic laws, you need a particular majority, and it's a simple majority, 61 members out of 120. That's nothing, because any government in Israel, we don't really have separation of power between the government and the Knesset. Members of the government, they are members of the parliament. And therefore, any government has 61 votes. Therefore, this is nothing special. This is not something difficult to get 61 votes if you want. We don't. Our political system is way different than the American one. You go to the election day, you elect 120 members of the Knesset, and then one of them will compose the government. He will be the prime minister, and the other ministers will be out of the Knesset itself. So the extreme majority of the ministers in Israel serve at the same time as members of the Knesset. So they don't really criticize or check and balance themselves. That's quite, when politicians speak about separation of power when it comes to the court, I always recall them, what about separation of power between the parliament and the government? So that's a very important point.
Okay, so basically we're saying it's a shift in two votes, not just that two votes that would make a difference.
Right.
Yeah.
Thank you.
Okay, so from an American Jewish perspective, one of the things we watch most closely are the issues having to do with the religious courts, with the treatment of reform and conservative movements. And of course, as you know better than I, Israel continues to have the old millet system, which it inherited from the Ottoman Empire, in which there are courts of each religion, at least large religious group, that determine personal status matters. And of course, in addition to those issues of how you govern vis-a-vis personal status matters, there are also issues of, control of kashrut certification, what situation of the Kotel is going to be. Could you talk a little bit about how you see that existing structure and what possibilities there are for change that would allow some of the control that the chief rabbinate has, and perhaps there are similar things in the Muslim community as well, where there's concern about the control that the religious courts have over people's lives.
You know, once I wondered why the Ottoman Empire decided to follow this path, namely, when it comes to questions of person status issues, to leave it each for his own religion. You have rabbinic courts, Muslim courts, Sharia courts, and church courts. I found, to the best of my understanding, two reasons. One, as a matter of respect to other religions. Those who are familiar with Islam, in Islam, you don't intervene into other religions. I mean, you propose to people, I'm not talking about ISIS nowadays, which is way far from Islam, of course, but you try to convince people to become Muslims. But if they don't want, particularly those who believe in the book of God, namely Jews and Christians, you don't touch them, you allow, you even protect them. That's one reason. But the other reason, the Ottoman Empire was not only a Muslim empire, but it was a kind of modern political empire. It had its own aspiration. And therefore, they didn't want to get involved in issues which might become sensitive. So they put aside all religious issues in order not to touch them, allowing, people to take care of their own God. When the British mandate came here, they followed the same path. I dare to say for the same reason, the second reason. When it comes to Israel, it's quite, reading through the proper literature on the field, they decided to do so particularly because when you read the partition plan, namely Resolution 181 of the United Nations, which ultimately it was incorporated in the Declaration of Independence, it guarantees the protection of religions, of other religions in the Jewish state. So it was a good idea. Now, I doubt if this was thought of as a permanent solution, but it was definitely a solution for the beginning years of the state. But in Israel, whatever it's temporary becomes permanent later on. Now, this kind of apparatus in Israel gave great power to religious courts, amazingly great power. Basically, the Supreme Court of Israel, which is the secular court, did not intervene in any decision of the religious courts. Even when the Supreme Court decided after 1992 that it has the authority to intervene in certain cases, these had been seriously exceptional circumstances. And I can recall 2 or 3 cases where the Supreme Court decided to intervene based on quality principle. But 99.9% of the cases are dismissed by the Supreme Court. Now, this has to do a lot with the political power that religious parties, particularly the Jewish parties, have in the Knesset. From the first day of the State of Israel, particularly after 1992, the Rabin government, for many years, the ultra-Orthodox Jews have been part of the coalition, whether it's the left or the right. Only in rare cases it has been, such as nowadays in the opposition. And even when they are in the opposition, it is interesting to see that their political interests are protected this way or the other. By whom? By other parties of the opposition, the Arab parties. They protect each other on issues related to religion. Even if these Arab parties are not religious ones, and there are a few Arab parties in the Knesset, are like the communist ones, they don't believe in God in the first place. So that's an interesting point of view. To what extent I see that this thing changes, it depends. First of all, I think it's not going to change in the coming few years. When I say coming few years, I say definitely the coming 30, 40, 50 years. And that's not only because of the political structure of Israel, but also because I think that the Supreme Court of Israel is not willing to take one step forward in this track for good reasons. Sometimes there are things that need to come from the parliament itself. However, what is good about that is that the Supreme Court is well aware of the sensitivity and of the complexity of issues, and therefore it is ready to intervene in particular cases where, because of religious rules, you reach the red line where you harshly, severely violate human rights. Now, a few years ago, president decision was taken in Israel. For the first time in history, a female was appointed as Qadi in the Sharia court. A lady, an Arab Muslim lady, was appointed to become a judge in the Sharia court, the Muslim court. That happened in the term where the Minister of Justice was Ayelet Shaked. The ultra-Orthodox politicians supported the move, however, on one condition: you won't come to us later on and ask us to do the same thing in rabbinic courts.
Well, yeah, I recall that this is probably going back at least 20 years, that when there was a woman appointed to one of the community councils, which were religious bodies, that this was an enormous to-do as well. I suspect it's, the Jewish Community Council, that there was a big fuss about that as well, and yet that came, over time, that came to be seen, I think, and tell me if I'm wrong on this, that came to be seen as not such a big deal any longer. So these things have, it's a process, I suppose.
That's true, but it's an exception. I mean, first of all, those who are familiar with religious laws, Christianity, Islam, and Judaism, know that none of this has to do with the rules of religion. Honestly, I mean, I'm quite familiar with the Bible and the Quran, and I know that there is nothing that supports the view that women cannot be judges. To the contrary, Prophet Torah was the smartest among prophets. Second, with all the modesty, I do believe that when it comes to leadership, women are more courageous than men to start with. So this is a statement that is very important to be made. And they have demonstrated such creativity and courageousness in different positions. Especially, you see that in the Supreme Court of Israel, led for the last 3 terms by a female. Esther Chayut, Miriam Naor, and Benish.
I hear you saying that in that changing the roles of the religious courts is going to be more of a political matter than it is a juridical matter. But will it make a difference if, say, you have a Supreme Court that has more Muslim and Christian justices on the court? Is that perhaps something that's going to break this logjam, or you don't see that as making a difference?
First of all, I don't think it makes difference because, but if we read the written law, the Supreme Court of Israel is not bound by its own precedents. However, practically speaking, the Supreme Court is bound by its precedents. So whenever there's any change, it doesn't happen like in, all of a sudden. There's kind of a process for this to happen. That's one thing. Second, you have only one Muslim justice of the Supreme Court
now
to be appointed, and you have nowadays one Christian. And even if they are liberal judges, you can see that even the Supreme Court of Israel, at its best, when it included more liberals than conservative, they didn't make that move. So to expect that the conservatives will make the move, and we have quite a good number of conservatives at the Supreme Court nowadays, it will be quite awkward to believe so.
Okay, I want to turn back to the issue of, to the extent we covered already, the issue of discrimination against minorities. I have a couple of questions that, trying to get a little bit more into the weeds. So let me just tell you what the questions are. One question has to do with During the unrest in May, in Jaffa, police were stopping Arab food couriers and taking away their motorcycles, even though they were delivering food and out of danger. To what extent could and should we expect the courts in Israel to address the police's unequal treatment of Israeli Arab citizens? And then related to that is the question of whether Israel has anything like Title VII in the United States, which prohibits discrimination on the basis of religion, national origin, race, etc. And to the extent there is such a thing, how are those enforced? So these are both questions about the mechanisms of protecting minorities from discrimination, either by police enforcement or in employment. What is there, and how good a job is being done in protecting against that kind of discrimination?
Well, I started by telling you that our basic human dignity and liberty does not provide any constitutional protection to the right to equality. And even the recent legislation of basic law, Israel, the nation state of the Jewish people, omitted the legislature omitted the inclusion of the equality principle. However, the Supreme Court of Israel has decided in many precedents that equality is part of dignity, and to the extent that the dignity is violated, therefore equality as a principle is guaranteed. At the same time, we have quite a number of good laws, statutes, regular statutes in Israel that protect equality for women, for disabled people, for the Arab minority in terms of affirmative action, and some kind of this sort of laws. When it comes to the police in general, and I have heard, I think, the commander-in-chief of the police forces in Israel, or someone representing him, admitting that the police in Israel is not qualified enough to deal with multiculturalism. Israel is one of the most multicultural countries in the world. Sometimes in the same village you have something like 5 to 10 different cultures. And it means when you approach somebody, there's a way how to approach him. Or when you knock the door of somebody, there's a way how to do that. Or say, for instance, if it's the Ramadan, you don't go and knock the door of somebody in order to question him at the time of breaking the feast. So there are, same goes with the Ethiopian, with the Russian, with the Mizrahi, with the Ashkenazi, with the ultra-Orthodox, and other groups in Israel. When it comes to minorities, one of the most important tools for them to express themselves usually is when they exercise the right to freedom of expression, assembly, protest march, of course, not in violent way. When it comes to violent way, the police forces need to take control over the situation. But here, taking control over the situation does not mean necessarily do whatever you want. It means that there are proportionate means that you can adhere to in order to reach the goal that you want to reach, which is peace in the public area, and at the same time, as less violation as possible of human rights, particularly against their body integrity. The May events is one of the most sad points in our history as citizens of the State of Israel, Jews and Arabs alike. Many people, particularly politicians, keep arguing that we lost more people from our side than the other side. They were more violent than us. This is not the way you look at it. We are all Israelis. We found ourselves in a nightmare overnight. We disgusted ourselves the way some of us behaved against their neighbors, people with whom they live day to day, make business with, say hello in regular days. And we forgot all of a sudden about our humanity. I don't want to say that the May events are going to change our reality to the worst, but we have to remember and co-memorize the May events day and day in order to avoid reaching this point again. For this to happen, not only the people need to remember that, but also the government and the police forces need to remember that. And when I come to the government, it is time to remind them that the police is a very important institution that needs to be empowered, not to be weakened. For many political reasons, we have heard many politicians aiming at weakening the police forces, whether because they have something against them or criminal indictment has been submitted against them. You don't play that game with the police forces, because we need them, not for our personal interests, but we need them as citizens. They have the authority to secure our lives, whether we are in power or not in power, whether we are part of the majority or the minority. When it comes to the Arab minority citizens of Israel keep recalling the report by the OR committee in 2000 that declared or stated that the police forces in Israel perceive the Arab minority as the enemy and they treat them as the enemy. So, as a matter of fact, it has been written there by a public state committee, and this should be respected, and we should learn from that and see how we can change things. But at the same time, I dare to say that also the Arab minority in Israel has been perceiving the police as the enemy. And this attitude should be changed. It should be amended from both sides. If I understand that when I approach the police, I approach him or her because they are there to serve me as citizen of the state, if they approach me and see me as I am, as a citizen, as a person, regardless my name or my nationality or my religion, I think that I go back to the dance, we can dance together again in a way better style. We can even get more benefits from this kind of dance, way more than the disadvantages that exist nowadays with this hostile attitude, for mutual attitude from both sides.
There's a lot of that, and as has been the case with much as we discussed, a lot of parallels to the conversation taking place in the United States. Those who want to talk about defunding the police versus those who are saying, no, what we need is police reform. We need better training of police for interactions with communities. So there's a lot of parallels there. I have one last, unfortunately, we're running out of time. There's more questions than I could possibly ask, unless we want to stay on for another hour and a half. But I want to ask one last question and then invite you to make any closing comments that you would like to make as well. And this last question, and maybe the answer to this is the same as the question I asked about protecting equality and the gaps in Israeli basic law as far as that goes. The protection of free exercise of religion. I mean, it's sort of odd to raise this issue in the context of the Jewish faith, but I have seen instances where cases reported where somebody Jewish wanted to take off for Shabbat, and the employer didn't want to give them that time off, and there was some question as to whether Israeli law would protect them, protect the employee in terms of exercising their religious freedom. And so I want to ask you to what extent, if any, there are explicit or implicit protections of the free exercise of religion in Israeli law, and if so, at what point does the government have a legitimate authority to say, no, there are certain practices we're not going to let you exercise because they're harmful to the larger society? So that's my last question. It's this sort of bundle of issues about protection of free exercise of religion.
I will answer you in two levels. In principle, first of all, the whole laws of employment in Israel are incorporated in certain particular laws, and we have a special tribunal that deals with questions of employment. That's a very important thing. So when you want to go and submit a complaint in issues regarding even discrimination in employment or any other issue related to your employment, you would go to this particular tribunal. If you want to submit a petition on these particular tribunals, you go to the High Court of Justice. Now, why am I saying this this way? Because the Supreme Court of Israel has two capacities. Now, it's the same building, the same 15 judges, but it serves at the same time as the Court of Appeal on civil and criminal issues, but it also serves as the High Court of Justice, namely as a court of first instance. You submit a petition to the Supreme Court against any governmental action, including issues related to religious courts or to employment courts or other particular courts that exist. The Supreme Court of Israel, as a High Court of Justice, has been very active in protecting human rights of the employee since the very inception of the State of Israel, particularly after 1992 with the legislation of basic human right and human dignity and liberty, to the extent that the constitutional revolution was even incorporated in certain precedents of the Court of Employment, and the Supreme Court of Israel has endorsed these precedents to become valid, binding on all of us. Justice Barak, not Aaron Barak, but his wife, she was the vice president of the Court of Employment. So I dare to think that the same attitude of thinking was influencing in both the areas. That's in principle. Now, as a matter of ad hoc situations, the point of balance between human rights and other public interests depends on the particular circumstances. And therefore, if you ask me about a particular case, I can't give you an answer. But in principle, the answer would be, it depends on the particular case. Having said that, we have to mention that remarkably, in a good way, Israel has been very tolerant to religion issues, not only the Jewish religion, but also Islamic law and the rights of Christians and even Druze and others. So as a Muslim, I can enjoy my holidays when it comes to my work. As a dean, I can tell you that even the High Council for Higher Education in Israel has forced the universities, the public universities and the public colleges, that we have to respect the holidays of other religions, and they enlisted all the religions that need to be protected. So if my student could not come to class or to take exam because he has a religious holiday, then I have the duty to make sure that he has a makeup so that he can take his or her exam. So I hope I addressed your question.
Yeah, thank you very much. Did you have any concluding thoughts that you want to share with us as we begin to wind down?
Well, thank you first of all for having me here. I'm one of the very enthusiastic advocates for the legal argument that Israel was established as a Jewish and democratic state, so it has to remain in the future. I believe that the self-legitimacy of the state of Israel is grounded on defining Israel as a Jewish and democratic state. If we focus on the universal aspects of Israel's Jewishness, not in the religious point of view, but in the more heritage issue, nationalistic even issue, reading Jabotinsky, for instance, for those who have read Jabotinsky. And if we focus on the universal aspects of the democratic values and then strike the balance between both of them, I think we can be in a very good position. The Supreme Court of Israel, for many years, has been playing this role. The Supreme Court of Israel has been paid much attention by many countries in the world because it started learning from other countries, but at a certain point, it started even importing important decisions, interesting decisions, with very clear wisdom of legal decisions on very complicated issues to be learned from. I would like to ask you to pay attention to these cases. I know that I'm not going to change the policy in America, but at least when it comes to jurists, they can read cases from the Supreme Court of Israel. And I'm quite sure that you can play a very important role in developing our rule of law in Israel, because we have lots to learn from your constitutional law, heritage, and also contemporary constitutional law. So thank you again for having me here, and I hope we can keep in touch.
Well, I thank you very much. I like to think we can learn from each other, that Americans can learn from Israelis, Israelis can learn from Americans. And I think this balance of the particular and the universal for someone, as someone who works in the civil rights area, where I was both representing the particularist interests of the Jewish community, but also an advocate for universal human rights. This is a balance in all of our lives. And I think it's an important one to keep in mind, and to always be aware that both of those are parts of our identities and our values. So thank you, Mohammed, Professor Wattad, very much. It's been an honor and a pleasure. It's been a fascinating conversation. I hope our participants find it so as well, and I thank them for having listened in, as well as and asked good questions, as well as thank the sponsors of this event. And with that, I'm going to turn it over to Harvey Ryder, who's going to take us out. Harvey, please.
Thanks, Richard, and thanks, Mohammed, so much for joining us today and for giving of your time so generously. I know that there are so many questions people had to ask that they won't get a chance to ask, and we just can't go on long enough. But this has been a wonderful experience for all of us. I just want to remind you that we'll be having a number of other programs coming up in the near future. Richard and I and Rhonda Lees have been coordinating on these programs for a number of years. And we'll send out notices of our future events. But Mohammed, I want to thank you again for taking the time to address our group. I know it was a meaningful experience for all those who attended, and we had lots of people here today. So again, thank you all. Look forward to our next brown bag or virtual brown bag program, and we'll see you then.
Thank you very much.
Thank you.